in advancing urban life along with increasing independency among the spouses, has increased the divorce rate in India. Even newly married couples are so much in stress, they seek for divorce. However, if both the parties, i.e. husband and wife, have the mutual consent for the divorce and there is no issue of child custody and alimony, then comparatively, it is easier to get divorce. Such divorce, technically known as divorce with mutual consent, usually takes 6 months and then divorce is granted. But if one party is not ready for the divorce and second party is desperate to get separated finally, then it is big issue. Such one-party divorce petition is pretty expensive affairs, as it will cost you too much money. As such there is no limit, and very long time, maybe 2 years, or 5 years, or even more, and after this much long time, there is no guarantee that you will get the divorce decree. So, in this video, I will be giving you certain tips that may help you to get one-party divorce easily and in less period of time. If you want to file one-party divorce petition, then first think, you should keep in mind that court won't give its decision based on your emotional story or your wish that you don't want to live with your spouse anymore. Whatsoever big your problem is, court is not at all interested in listening that, but rather court wants substantial proof and evidence. If you have it, you will get the divorce easily. I believe most of you know it that to file one-party divorce petition, the petitioner needs to give the ground or grounds of divorce. For one-party divorce there are certain defined grounds such as adultery, impotency, cruelty, desertion, religion change, insanity, incurable diseases, venereal diseases, change of religion, or renouncing the worldly life and becoming monk. So, along with the divorce petition, you also need to quote any one of the grounds or more than one ground on which you want divorce. But the problem is, you not only need to tell the ground on which you want divorce, rather you have to substantially prove that in the court. I mean, you have to convince the court that you are a victim and suffering a lot because of the given reason. Secondly, you also need to prove that you have taken all possible means to save your marriage, but nothing worked out and it is irreparably break down. Nothing remains in your marriage, so better to grant divorce. I repeat that court won't be convinced because of your emotional story, rather it needs substantial evidence and proof. Therefore, because of increasing marriage problem, don't get carried away and hire an advocate and file the divorce petition. Please don't do that, because it will further increase your problem. If you file such type of divorce petition, then believe me, you will be buying one more problem. So from now, you would have 2 problems, i.e. marriage problem and divorce problem in the court. Better don't do that. So, now the question is, how to convince the court that you are a victim? The only way to convince the court is, give the proof and evidence of your victimization. Normally, in most of the divorce cases, the common grounds of divorce are either adultery, cruelty, or desertion. So, whatever your ground is, even not from these 3, rather something else as mentioned above, solution is only one. Don't file the divorce petition, rather. You keep patience. Plan your divorce. Most importantly, start collecting the evidence secretly that your spouse does not know. For example, if you have the issue of adultery or cruelty or anything else, start collecting the evidence, such as phone calls recording, clicking pictures of any such offensive moment, any other documents such as hotel bill, medical bill, etc. that can support your ground of divorce. Especially, in the case of cruelty, don't forget to file an FIR, as the copy of FIR would be the great evidence of cruelty in the court. Do some marriage counseling to save your marriage, even you don't want, but plan it and do it and collect the report of such counseling along with fee receipt. Lastly, collect any such report, document that you believe could be substantial evidence in your case. So, plan and work on that sincerely for 6 months or even for a year and more than that. Believe me, it would not be a problem, because once you file your divorce petition with any such substantial document, your divorce petition will be granted merely after a few hearings. I repeat, without substantial evidence, court won't grant you divorce. So, why not first collect the evidence with the patience and then go court with all such documents? Rest life is yours, so choice will be also yours. However, still, if any one of you have any question, confusion, or want more information, then you may ask through the comment box given below or email us at mplegalfirm@gmail.com. And yes, if did not subscribe our channel by the time, then don't forget to subscribe it to remain updated with such informative videos. Wish you good luck. See you in next video.